Good morning, Alex and friends. I'm Grace. Today is Wednesday, April 29th, 2026, and you're listening to Alex's News. In Riverside, we are looking at a high of 76.5 degrees today with a low of 50.4, so it should be a mild and comfortable day across the region. On the program today, we are taking a closer look at the unusual legal situation James Comey is facing because of an Instagram photo of seashells he shared. We will also examine the intense privacy debate currently unfolding over California's controversial proposal to share information on local drivers. Beyond those major stories, we will have a roundup of other significant news events making headlines across the country and the world today. All this and much more on Alex's News. Please stay tuned as we get into all the details. Good morning, everyone. We're starting today with a major legal development out of North Carolina that's drawing national attention. A former FBI director is now facing federal charges, and the case revolves around a single social media post. For more on this, we're joined by our reporter, Ethan. Ethan, good morning. Can you walk us through what happened?
Good morning, Grace. So yesterday on April 28th, a federal grand jury in the Eastern District of North Carolina returned a 2-count indictment against former FBI Director James Comey. According to PBS NewsHour and NBC-DFW, the entire case centers on an Instagram post from May of last year. That post showed seashells arranged on a beach to form the numbers 8647. Officials in the Trump administration are calling it a coded assassination threat against President Donald Trump, who is the 47th president.
Wow. So a beach photo is now the basis of a federal indictment. What exactly are the two charges?
CNN was first to report the breakdown. The first count is threatening the president under Federal Statute 18 U.S.C. Section 871, meaning knowingly and willfully threatening to take the life of or inflict bodily harm on the president. The second count is transmitting a threat in interstate commerce under Section 875C, which covers the act of posting the image to a social media platform. Both are felonies, and prosecutors argue Comey knew exactly what the numbers meant.
And how is the Justice Department interpreting those numbers?
The DOJ argues that 86 is slang for killing, eliminating, or removing someone, and that 47 references Trump as the 47th president. But here's where it gets interesting. According to ABC 10, Merriam-Webster defines 86 primarily as restaurant slang, meaning to refuse service or to get rid of something. The dictionary does note a more recent and much sparser use, meaning to kill. The indictment claims a reasonable recipient familiar with the circumstances would interpret the post as a serious expression of intent to do harm.
That's a pretty narrow definition the government is leaning on. Where does the case stand procedurally right now?
As of this morning, April 29th, the case has been assigned to U.S. District Judge Louise Wood Flanagan. She's a veteran jurist appointed by President George W. Bush. The grand jury issued a warrant for Comey's arrest alongside the indictment, but Acting Attorney General Todd Blanche said at a news conference that the DOJ expects Comey to self-surrender in North Carolina sometime this week. No initial court appearance has been publicly scheduled yet.
Tell us a little more about Todd Blanche. He's a name some viewers may recognize.
Right, and his role here is significant. Blanche is the acting attorney general, and before taking that post, he was a personal lawyer for Donald Trump. PBS NewsHour reports that Blanche's aggressive push to secure this indictment is widely seen as an effort to prove his worth to the president in hopes of getting a permanent appointment. At his press conference, Blanche refused to elaborate on specific evidence about Comey's intent. He instead argued the case is similar to other threat prosecutions the department brings against less prominent people.
That's quite a comparison. What is Comey himself saying about all this?
Comey has, in his words, vigorously denied the charges. His legal team is led by attorney Patrick Fitzgerald, a well-known former federal prosecutor. In a video statement released on Substack, Comey said, quote, "I'm still innocent, I'm still not afraid, and I still believe in the independent federal judiciary," end quote. So he's signaling that he plans to fight this aggressively and publicly, and his defense team is already laying down its core message.
And what about the post itself? Did he address it when he originally put it up last year?
He did, Grace. According to ABC 10 and NBC DFW, Comey deleted the post shortly after it went up in 2025. At the time, he wrote, quote, "I didn't realize some folks associate those numbers with violence. I oppose violence of any kind, so I took the post down," end quote. He's consistently maintained that he assumed the numbers reflected a political message rather than a call for violence. His defense is expected to focus heavily on First Amendment protections and on the lack of evidence about his subjective intent.
You mentioned subjective intent. There's a Supreme Court case that comes into play here, right?
Yes, and this is really the legal heart of the matter. The viability of this prosecution faces scrutiny under the Supreme Court's 2023 ruling in Counterman v. Colorado. As noted in analysis from Lawfare and reported via Gemini Flash, the government now has to prove a subjective element of intent. Specifically, prosecutors must show that Comey acted with recklessness, meaning he consciously disregarded a substantial risk that his communication would be viewed as a threat. That's a much higher bar than simply asking how a reasonable person might have read the post.
Has this kind of numbered phrase ever been prosecuted before?
That's where the precedent gets thin. Legal experts cited by PBS point out there's really no historical precedent for prosecuting the term 86 as an assassination threat. Phrases like 8645, used against Trump during his first term, and 8646, used against Joe Biden, appeared widely on political merchandise and social media without anyone facing criminal charges. And back in 2018, the term 86 was famously used by a Virginia restaurant that refused service to Sarah Huckabee Sanders. That was never treated as a criminal threat either.
So this would be a real departure from how the government has handled similar language. Is this the first time the DOJ has gone after Comey under this administration?
It's actually the second time in recent months, Grace. Back in September of 2025, Comey was indicted on charges of lying to and obstructing Congress. But that case was dismissed by a judge in November of last year. According to ABC 10, that prosecution collapsed after the court concluded the prosecutor, Lindsay Halligan, had been illegally appointed. So this new indictment is essentially a second attempt to bring Comey into court.
And it sounds like this fits into a much broader pattern at the Justice Department.
It does. PBS NewsHour describes the current environment as a, quote, relentless effort, end quote, by the Justice Department to prosecute political opponents. In addition to the Comey case, the DOJ recently announced a prosecution against the Southern Poverty Law Center. They're also pursuing a criminal investigation into former CIA Director John Brennan. So Comey is one of several high-profile figures from the previous national security establishment now facing federal scrutiny.
Let's go back to the origins of all this. Trump and Comey have a long history. Can you remind viewers how this feud started?
Sure. The long-standing feud goes back to 2017, during Trump's first term. That's when Trump fired Comey while the FBI was investigating Russian interference in the 2016 election. The fallout from that firing shaped years of political and legal battles, including the Mueller investigation. So the personal animosity between these two men is nearly a decade old at this point, and it's clearly informing how this current case is being approached.
Has President Trump weighed in publicly on the seashell post?
He has, and pretty directly. In a Fox News interview, President Trump previously accused Comey of knowing, quote, exactly what that post meant, end quote. He went on to assert that, quote, it meant assassination, end quote. So the president himself has personally framed the post as a threat on his life, which adds another layer of political pressure to a case the Justice Department now has to prove in court under that stricter Counterman standard.
What should viewers be watching for in the coming days?
The big immediate question is when Comey self-surrenders in North Carolina. Acting Attorney General Blanche said that's expected within the week, so likely in the next few days. After that, we'll watch for the initial court appearance before Judge Flanagan and any early motions from Patrick Fitzgerald's defense team. I'd expect a First Amendment challenge fairly quickly, along with arguments about the subjective intent standard. This case could move slowly, but the legal questions it raises are significant.
And finally, Ethan, beyond the courtroom, what's the larger significance here?
I think the larger significance is what this signals about the use of federal threat statutes against political figures. If the government can build a felony case around a beach photo of seashells, that has implications for political speech well beyond James Comey. Civil liberties groups and legal scholars will be watching closely, as will lawmakers on both sides of the aisle. This case really sits at the intersection of free speech, presidential security, and prosecutorial discretion.
Fascinating and complicated story. Ethan, thank you so much for breaking it down for us this morning.
Happy to, Grace.
Now to a major privacy fight unfolding right here in California, where a Department of Motor Vehicles plan could affect more than 1 million undocumented immigrants. Joining me now is our reporter Chloe to walk us through it. Chloe, what exactly is the DMV trying to do?
Good morning, Grace. According to Cal Matters, the Los Angeles Times, and the Lost Coast Outpost, California is preparing to join something called the State-to-State Verification Service, along with its underlying platform, the State Pointer Exchange System, or SPEXS. That system is run by the American Association of Motor Vehicle Administrators, a private nonprofit governed by DMV officials from across the country. The goal is to let states cross-check driver records nationwide. But privacy advocates are calling this a, quote, direct betrayal, end quote, of promises California made roughly a decade ago.
A betrayal of what promises, exactly?
Back then, California passed Assembly Bill 60, known as AB 60, which allowed undocumented residents to get driver's licenses legally. The state assured those drivers their information would be protected from federal immigration enforcement. Now, more than 1 million people who signed up under that promise could have their data flowing into a national system. That's why groups like Oakland Privacy, the Electronic Frontier Foundation, and the Identity Project are sounding alarms.
I keep hearing about a code, quote, 99999, end quote. What is that?
That's really the heart of the controversy. To join the state-to-state system, California has to share the last 5 digits of license holders' Social Security numbers. But AB 60 holders don't have Social Security numbers, so the system substitutes a placeholder, the digits 99999. Advocates say that placeholder works like a digital scarlet letter, instantly flagging someone as undocumented.
And who could potentially see that flag?
That's exactly what worries privacy groups. They warn that federal agencies like Immigration and Customs Enforcement, or ICE, and Customs and Border Protection could use that marker to identify and target deportable individuals. Per LAist, even if California refuses to give ICE direct access, federal agents could go around state protections. They could ask law enforcement in another state to run a query, or they could use subpoenas to pry the records loose.
So it sounds like the data could leak out sideways. How much money is tied to this proposal?
The initiative is currently linked to a $55.9 million funding request in the 2026 to 2027 state budget. The DMV says it needs that money for IT integration and data cleansing. But, according to CBS 8 and Cal Matters, Senate Budget Subcommittee Number 5 discussed it in March and again this April, and the pushback has been intense. As of late this month, the subcommittee has, quote, held the item open, end quote, while it looks for stronger privacy protections.
Wasn't there also a separate bill connected to this earlier in the year?
Yes, that's a really interesting twist. Early in 2026, Assembly Bill 2156 was the legislative vehicle meant to override state privacy laws so this data sharing could happen. But in late March, that bill was, quote, gutted and amended, end quote, and now it focuses on completely unrelated topics. So the privacy override has shifted into the budget trailer bill process instead. Specifically, lawmakers are looking to amend Vehicle Code Section 1653.5, which currently bans sharing Social Security data for anything beyond taxes or child support.
That's a pretty significant change in venue. Why does the DMV say it has to do this at all?
DMV Director Steve Gordon argues California simply has no choice. He points to the Federal Real ID Act of 2005. As reported by papersplease.org, that act requires states to provide, quote, electronic access to all other states, end quote, for their motor vehicle databases. The idea is to enforce a, quote, one driver, one license, end quote, rule, and federal officials say the state-to-state system is the only way to comply.
And there's a deadline coming up, right?
2 of them, actually. The Department of Homeland Security has signaled it will only certify states as Real ID compliant if they join state-to-state. California has a technical onboarding deadline of February 16, 2027, set by the American Association of Motor Vehicle Administrators. That's roughly 9.5 months from today. If the state misses that window, it risks missing the final federal deadline of May 5, 2027, when California licenses would no longer be accepted for domestic air travel.
That would be a huge headache for travelers. Has the DMV offered any safeguards to ease privacy concerns?
They have, but advocates aren't impressed. The DMV has cited what it calls, quote, verbal assurances, end quote, from the American Association of Motor Vehicle Administrators. First, the system supposedly only allows one-to-one queries, meaning an official must already have a person's name and birthday to search. That's meant to prevent agents from pulling a bulk list of everyone tagged with the 99999 code.
What about subpoenas? Those are a real concern here.
They are. AAMVA has agreed to notify California if it receives a federal subpoena for the data, but officials admit that promise falls apart if the subpoena comes with a federal gag order, because then the state can't legally be told. Director Gordon also testified that the DMV tried to persuade AAMVA to use, quote, hashing, end quote, which means encrypted identifiers or some other unique code instead of the 99999 placeholder. AAMVA refused, saying no other options are currently supported for Real ID compliance.
Are there other states California can look to for guidance?
Yes, California is studying so-called sanctuary states that have already gone through this. New York and Illinois both use the same 99999 placeholder, but they rely on strict state laws to keep the data safe. New York has its green light law, which requires a judicial warrant for any immigration-related access to DMV records. So privacy groups argue California needs something similarly hard-coded into law, not just verbal promises.
And how is New York faring with that approach?
That's where things get complicated. New York is currently facing its own federal showdown. Earlier this month, U.S. Secretary of Transportation Sean Duffy announced he was withholding $73.5 million in highway funds. That's because New York refused to share, quote, lawful presence, end quote, data for commercial drivers, so even states with strong privacy laws are getting squeezed by the federal government.
What are advocates pushing California to do specifically?
Privacy advocates want one of 2 things written directly into the budget trailer bills. The first option is a, quote, California-only, end quote, verification method that would avoid sharing the data nationally. The second is a statutory judicial warrant requirement, similar to New York's green light law. They argue that verbal assurances from a private nonprofit, like the American Association of Motor Vehicle Administrators, simply aren't enough to protect vulnerable residents from federal overreach.
So where does that leave lawmakers right now?
Under enormous pressure, frankly. As of today, April 29, 2026, the California legislature has to weigh the privacy of 1 million AB60 license holders against the convenience of millions of other residents who need their IDs to fly. Senate Budget Subcommittee Number 5 is still holding the item open, looking for stronger safeguards. And the clock is ticking toward that February 16, 2027 technical deadline.
Is there any indication of which way the legislature is leaning?
Not yet, Grace. Lawmakers are caught between competing realities. On one hand, they don't want to break a decade-old promise to undocumented drivers. On the other, they don't want Californians turned away at airport security checkpoints next May. Expect the budget negotiations over the next several weeks to be where this really gets decided.
And practically speaking, what should our viewers who hold these licenses be doing right now?
Honestly, Just stay informed and pay attention to the budget hearings. Nothing changes overnight, and the $55.9 million hasn't been approved yet. Advocacy groups like Oakland Privacy, the Electronic Frontier Foundation, and the Identity Project are tracking every committee hearing and amendment. Anyone concerned can reach out to their state senator, while Subcommittee Number 5 still has the item open.
Really important reporting on a complicated story. Chloe, thank you so much for breaking it all down for us this morning.
Thanks for having me, Grace.
Here are some other headlines. The United Arab Emirates is making a crude exit from the OPEC alliance, effective May 1, 2026, in a move that really greases the wheels of their own national interests. The state-run news agency describes this departure as a policy-driven evolution. It seems the Emirates are tired of being refined by cartel quotas. They are looking for the flexibility to pump out 5 million barrels per day by 2027. This high-pressure split follows deepening friction with Saudi Arabia and a lack of energy regarding collective responses to Iranian strikes on regional infrastructure. While the immediate market impact might be bottled up due to the closure of the Strait of Hormuz, this move pipes down OPEC's ability to dictate global prices. It is being viewed as a slick strategic win for the United States, allowing the Emirates to forge independent partnerships with major consumers like India and China. Moving to the legal docket, Judge Madeline Cox-Arleo has given the final dose of approval for Purdue Pharma's criminal sentence, clearing the path for the OxyContin maker to be dissolved by the end of the week. It is a bitter pill to swallow for many, but the company will be replaced by a new public benefit entity known as Knoa Pharma. This new firm, overseen by a board appointed by the states, is tasked with finding a medicinal remedy for the opioid crisis. The sentence includes a $3.54 billion criminal fine and a $2 billion forfeiture, though the Department of Justice will only collect $225 million to ensure remaining assets flow toward state and local settlements. Meanwhile, the Sackler family is expected to cough up $7 billion over 15 years as part of a larger $50 billion agreement. While officials praise this as a measure of accountability, over 900,000 families feel the settlement lacks the proper prescription for justice, since no individuals were held criminally responsible. In domestic policy, the administration is moving to implement a rule change that could significantly slash supplemental security income for hundreds of thousands of disabled adults. According to an investigation, the new policy would treat shared living arrangements as in-kind support, effectively telling recipients there is no such thing as a free lunch or a free bedroom. This could cut monthly checks by one-third, or roughly $330, impacting 400,000 individuals, including those with Down syndrome, autism, and dementia. While the Department of Government Efficiency looks to trim the fat from federal spending, advocates warn the move will push vulnerable families into a deep financial hole. The Supreme Court is also weighing in on a case that could pull the rug out from under hundreds of thousands of immigrants. Oral arguments began today in the consolidated cases of Mullen v. Doe and Trump v. Miot, which will determine the fate of temporary protected status for 350,000 Haitians and 6,100 Syrians. The Department of Homeland Security argues it has the sole authority to end these protections, but plaintiffs claim the move is fueled by racial animus. A ruling in favor of the government could set a precedent that puts 1.3 million people from 17 different countries in a very precarious position. Finally, Meta is finding itself in a bit of a face-off with the European Commission. Preliminary findings suggest the tech giant is in breach of the Digital Services Act for failing to keep children under 13 off Facebook and Instagram. It turns out their age verification measures were about as solid as a house of cards, relying on self-declarations that kids could easily swipe past. Approximately 10 to 12% of underage children in the region are still logging on despite the rules. If these findings stick, Meta could be looking at a fine of $12 billion, or 6% of its global annual revenue. It seems the European Union is determined to make sure the company finally grows up when it comes to child safety. That's all we have for now. Today's episode was made by Alexander King with Claude Opus 4.6, Gemini Pro 3.1, Gemini Flash 3, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.